Hello, ma'am. I am Miles Kagapae and live in Barangay Trishata, Negros Oriental. Hello, ma'am. I am Miles Kagapae and this is my video presentation about our last chapter, which is chapter 4 in Ca200. Chapter 4 topics. The Bureau of Corrections RA 10575, Custody, Security and Control of Prisoners, Care and Treatment of Prisoners, Release of Prisoners, Good Conduct Time Allowance, GCTA, Prohibited Acts, Subjects to Disciplinary Actions, BJMP, RA 6975, Republic Act 9263, Treatment of Special Needs or Unusual Offenders, Emergency Plans, Movement or Transfer of Prisoners, Detainees, Privilege of Detainees and Sentenced Prisoners. The Regional Rehabilitation Centers for Youth, the Child and Youth Welfare Code, the Death Row and the Rule on the Writ of Amparo. The Bureau of Corrections RA 10575, Republic Act number 10575 is an act strengthening the Bureau of Corrections or BUCOR and providing funds. Therefore, be it enacted by the Senate and House of Representatives of the Philippines in Congress assembled. Section 1. Short title. This act shall be known as the Bureau of Corrections Act of 2013. Section 2. Declaration of Policy. It is the policy of the state to promote the general welfare and safeguard the basic rights of every prisoner incarcerated in our national penitentiary. It also recognizes the responsibility of the state to strengthen government capability aimed towards the institutionalization of highly efficient and competent correctional services. Towards this end, the state shall provide for the modernization, professionalization, and restructuring of the Bureau of Corrections, a BUCOR, by upgrading its facilities, increasing the number of its personnel, upgrading the level of qualifications of their personnel, and standardizing their base pay requirement and other benefits, making it at par with that of the Bureau of Jail Management and Penology or BJMP. Section 3. Definition of terms. A. Safekeeping, which is the custodial component of the BUCOR present correction system, shall refer to the act that ensures the public, including families of inmates and their victims. The national inmates are provided with their basic needs, completely incapacitated from further committing criminal acts, and have been totally cut off from their criminal networks or contacts in the free society while serving sentence inside the premises of the National Penitentiary. This act also includes protection against illegal organized armed groups which have the capacity of launching an attack on any prison camp of the National Penitentiary to rescue their convicted comrade or to forcibly amass firearms issued to prison guards. B. Reformation, which is the rehabilitation component of the Bucor's present correction system, shall refer to the acts which ensure the public, including family of inmates and their victim, that released national inmates are no longer harmful to the community by becoming reformed individuals prepared to live a normal and productive life upon reintegration to the mainstream society. Section 4. The mandates of the Bureau of Corrections. The Bureau shall be in charge of safekeeping and instituting reformation programs to national inmates sentenced to more than 3 years. Safekeeping of national inmates. The safekeeping of inmates shall include decent provision of quarters, food, water, and clothing in compliance with established United Nations standards. The security of the inmates shall be undertaken by the custodial force consisting of correction officers with a ranking system and salary grades similar to its counterpart in the BGMP. B. Reformation of national inmates. The reformation program, which will be instituted by the Bucor for the inmates, shall be the following. Number 1. Moral and spiritual program. Number 2. Education and training program. Number 3. Work and livelihood program. Number 4. Sports and recreation program. Number 5. Health and welfare program. Number 6. Behavior modification program to include therapeutic community. The reformation program shall be undertaken by professional reformation personnel consisting of corrections technical officer with a ranking system and salary grades similar to correction officers. Correction technical officers are personnel employed in the implementation of reformation programs and those personnel whose nature of work requires proximate or direct contact with inmates. Number 2. Corrections technical officers include priests, evangelists, pastors, teachers, instructors, professors, vocational placement officers, librarians, guidance counselor, physicians, nurses, medical technologists, pharmacists, dentists, therapists, psychologists, psychiatrists, sociologists, social worker, engineers, electrician, agriculturists, veterinarians, lawyers, and similar professional skills relevant to the implementation of inmate reformation program. Section 5. Operations of the Bureau of Corrections. Number A. The Bucor shall operate with their directional structure. It shall undertake reception of inmates through its Directorate of Reception and Diagnostics DRD, formerly Reception and Diagnostic Center. Provide basic needs and security through its Security and Operations Directorates. Administer reformation programs through its reformation directors and prepare inmates for reintegration to mainstream society through its Directorate for External Relations, formerly External Relations Division. B. The DRD shall be responsible for the conduct of qualifications of each and every inmate admitted to the Bucor. Inmates shall be classified according to society risk and sentence. Included in the classification is determining inmate certain skill or talents, physical, spiritual, social, mental, and psychological evaluation, and other behavioral assessments as reference of the DRD preparation of individual inmates reformation program. Letter C. Aside from those born of the provision under Rule 8, Part 1, Rules of General Application of the United Nations Standard, minimum rules for the treatment of prisoners and that of the existing regulations of the Bucor on security classifications. Republic Act 10592 was enacted in 2013, amending RA 3815 or the Revised Penal Code RPC. The law increased the GCTA of prisoners to be recredited in the service of their sentence. Last June, the Supreme Court ruled that the law should apply retroactively. Some lawmakers, including Senate President Vicente Tito Soto III, are calling for the review of the law. But what exactly is GCTA? Can all prisoners benefit from it? Here are 4 things you should know. What is good conduct time allowance? Good conduct time allowance or GCTA is a sentence reduction provision afforded prisoners who show good behavior. It has been in existence since 1906. An Act 1533 provided for the diminution of sentences exposed upon prisoners is consideration of good conduct and diligence. Citing a 1908 decision, the SC said the law served a double purpose: to encourage the convict in an effort to reform and induce habits of industry and good conduct in the person beyond one sentence, and aid to discipline various jails and penitentiaries. 24 years later, the RPC, a legal code governing crimes and their punishment, was signed into law, incorporating good conduct time allowances for any prisoner in any penal situation. What is our RA 1059-2 and how does it work? In May 2013, then President Benigno Noynoy Aquino III signed RA 10592, amending Articles 29, 94, 97, 98, 99 of the RPC, which sought to expand the application of the GCTA to those under preventive imprisonment or those detained prior and during criminal trial who are deemed too dangerous for release. Increase the number of days that may be credited for GCTA. Allow an additional sentence deduction for 15 days for each month of study. teaching and or mentoring service, and expand the special time allowance for loyalty, and make it applicable to those under preventive imprisonment who can benefit from the law. Inmates who display good behavior and no record of breach of discipline or violations of prison rules and regulations may be eligible for GCTA according to the Bucor Operating Manual as cited in the SC decision. The IRR or of RA 1059-2 defines good behavior as the conspicuous and satisfactory behavior of a detention or convicted prisoner consisting of active involvement in rehabilitation programs, productive participation in authorized work activities, or accomplishment of exemplary deeds coupled with faithful obedience to all prison jail rules and regulations. Source: Supreme Court GR number 212719 or GR number 21467, June 25, 2019. Over the past years, Sanchez was found to have violated jail policies according to reports from Philstar.com, Rappler, and CNN Philippines. In 2006, a complaint was filed against Sanchez for allegedly possessing shabu and marijuana. In 2010, a kilo of shabu worth 1.5 million was discovered in one of the Blessed Virgin Mary statues inside his cell. 5 years later, an air conditioner, flat screen television, and refrigerator was seized from his cell. Sanchez also tested positive for illegal drug use, according to a Bucor report. Who are excluded from the law? Recidivists, or those who have been convicted previously twice or more times of any crime. Habitual delinquents, escapees, and persons charged with heinous crimes are included from its coverage according to Section 1 of RA 100592. The law, as well as RPC, however, does not define what constitutes a heinous crime. Under RA 7659 or the Death Penalty Act, heinous crimes are grievous, odious, and hateful offenses in which by reason of their inherent or manifest wickedness, viciousness, atrocity, and perversity are repugnant and outrageous to the common standards and norms of decency and morality in a just, civilized, and ordered society. The Death Penalty Act, which was repealed in 2006, classified murder and rape as heinous crimes that may be punishable by death. In 1995, Sanchez and 6 and 6 others were sentenced to 7 terms of reclusion perpetua for the brutal rape and murder of University of the Philippines Los Baños student Ilen Sarmenta, and for the torture and murder of Alan Gomez, another student 2 years prior. Under the RPC, the maximum detention period is 40 years, regardless of the number of terms that one must serve. So this means Sanchez will serve only 40 years in prison at most, even he was sentenced to 7 terms of life. Section 25, Supplementary Application of the Rules of Court. The rules of court shall be applied supplementarily insofar as it is not inconsistent with this rule. Section 26, Applicability to pending cases. This rule shall govern cases involving extra illegal killings and enforced disappearances or threats, therefore pending in a trial and appellate court. Section 27. Effectively, this rule shall take effect on October 24, 2007, following its publication in 3 newspapers of general circulation. That would be all. Thank you.